Go ahead and call roll.
Representative Bear,
Here.
Representative Burkhart,
Here.
Representative or Vice Chairwoman Duncan,
Here.
Representative Air,
Here.
Representative Gray,
Excused.
Representative Heiner, Representative Sherwood. Here. Representative Western.
Here.
Chairman Greer.
Here.
All right, so this morning, we're going to start with House Bill 125. Good morning.
Thank you, Madam Chair, members of the committee. I bring you House
Please
Bill.
introduce yourself.
Oh, I'm
for
so
all of
sorry.
us.
I am Representative Kathy Connolly, House District 13. And I bring you House Bill 125. The background on this bill goes all the way back to the first special COVID session where we needed to address the impact of the pandemic on employers and employees in relationship to illness and the workplace. And if you remember, we modified our statutes to establish a presumption of COVID transmission at a workplace so that an employee would be eligible for workers' comp rather than unemployment. And the employer's unemployment rating wouldn't be negatively impacted and would remain stable. We were all really kind of pleased about doing that. And I think I honestly was deputized as an adjunct member of this committee because I enjoy looking and thinking about these kinds of issues. But in the midst of that work, we recognize that a significant portion of our population is not covered by workers' comp. And as a state, we only require workers' comp in hazardous workplaces, plus we allow other employers to opt in to the state worker comp system, which many of them do. Remember that workers' comp is a grand bargain that employers and employees agree to. No one wants a workplace injury, right? And we have safety regulations and rules and a system where when an accident does happen, the injured worker receives the care that they need through the workers' comp system and that the employer has paid into. That's the way it works. And in exchange, the employee cannot sue, right? That's the grand bargain. But remember, not all employers in Wyoming choose to be part of our workers' comp system and instead are self-insured. They carry their own insurance for workplace accidents. And if there's a conflict with the employee over care, the employee is obligated to sue. 2 years ago, when we added a presumption regarding COVID to workers' comp, all these self-insured employers and employees were not and could not be included, and both had to rely on unemployment, and both had to rely on what I call Mr. Google for information. We were all in uncharted territory. All workplace injury systems think about injuries that are caused by, like, for example, a box falling down and injuring someone, a slip and fall, a manufacturing malfunction, something like that, where you have easy lines of causation. Those didn't and don't exist for COVID. So over the interim, so we were thinking about this, but we couldn't do anything about it. Right? We can only address the statewide workers' comp system. So over the interim, the chair of labor health and I thought about this issue, and we started by looking into what other states are doing in general with workers' comp. There's lots of different systems. Many states require all employers to be part of workers' comp. Other states, for example, have a parallel program for self-insured employers in their statutes, and they have a small administrative fee. All right, we didn't want to go down that road, right? We didn't want to go down that road. But we also knew that we couldn't modify our workers' comp statutes because workers' comp is wholly administered, right, and paid for by employers who have opted in. It would be unfair for those employers to pay for services that go to self-insured employers who don't pay in. All right, so that would be unfair. But we wanted self-insured employers and employees to be able to access DWS, our Department of Workforce Services, in order to get information, in order to get guidance when a workplace injury, including something like COVID, happens. So that's what this bill does. It is a small first step in that direction. And it does it by modifying Title IX, which you'll notice is not workers' comp. It's under Title IX is the administration of government. It has in it the duties of the directors of the executive branch. And so what this bill does, and the meat of the bill is on page 2. You could turn there. It has the director and the Department of Workforce Service provide information and guidance in employers and employees regarding workplace injuries, and to disseminate information and provide a report. And again, this is under Title IX, not under Title 27. And so though that information will include the rights and responsibilities of employers and employees under the law, again, for both those that are under workers' comp and those that are self-insured. On page 3, the administrative processes under workers' comp, the completion of forms for any administrative process, available local, state, and federal aid for any workplace injury. And it has information on the liability insurance that's available to those that are self-insured. The last portion of the bill is simply a report, and you'll see that, with DWS, we've come up with an amendment that actually simplifies the paperwork for DWS and has them report under this section under an existing report that they're already obligated to put in. So with that, Madam Vice Chair, Mr. Chair, and members of the committee, I'd be happy to take any questions.
Any questions, committee? No? Yes? Chairman?
Yep. Madam Chairman, I don't know so much of a question, it may be a bit of a comment and why I am a co-sponsor on this bill, but I find when I was practicing law, I advised a lot of small businesses, and many of them were farms and ranches. And what I found seemed to be a mentality that the least workers' comp premium you had to pay, the better you were for your overall operation. So ag exemptions were used heavily. There was a lot of misinformation or people who didn't understand what they could do if they were in an LLC or a single member LLC or a family held corporation, which you see a lot of. And I always would advise people that they should pick up workers' compensation on their employees and including themselves, because of one, workers' compensation in Wyoming is really a good program. It limits the liability of the employers, and it really does a good job of taking care of the employees. It's a trade-off. And so I'll just say, after years and years of advising people, I received a lot of feedback from folks saying, Mike, we're glad that you advised us that way. We had this accident and this employee had immediate medical treatment. We also weren't subject to liability. I had the situation, I think of one who consider a friend. He feeds our cattle now, but it just tore a rotator cuff getting out of the tractor. He had poor health insurance with a high deductible, and wow, he got covered in the temporary total disability because he had to hire someone to replace him. It worked well. My thoughts on this bill is that even though the majority floor leader was talking in terms of another pandemic and the confusion and things associated with that, is simply just what can we do to allow people to have better information, better understand the exemptions, better understand, and because the exemptions aren't good, people think they are, but better understand what coverage is there and what it can do for smaller businesses. And so those were my comments. I guess, Madam Minority Floor Leader, in the interest of this, do you agree with my comments?
Mr. Chairman, absolutely, absolutely. And in all honesty, I hope that this body over, the next several years actually takes a good look at the system for exactly the reasons that you just illustrated. That this is honestly a tiny first step in getting information out to those both employers and employees at this point who aren't under the system. And honestly, it might help them to decide that, in fact, this is a better system than what they have right now, all the way around.
Representative Heiner?
Thank you, Madam Chairwoman. Couching off of the comments of the good chairman, I find it amazing that we are not already disseminating this information out. That, this seems like a responsibility of the Director of Workforce Services to do this already. So my question is, why does this need to be in statute to have him do something that should already be part of his job scope?
Yeah. Madam Chair, Representative Heiner, I read the entire 2714, looking for that. And honestly, our workers' comp statute really is wholly and only designed for those employers who are obligated to participate or who opt in. And so that information is not included in here. And so it's honestly that those businesses are out on their own. And so that's why, and actually the department is here, and the department will, I won't speak for them, but they will speak in favor of this. But this now gives them the opportunity to respond to those phone calls that they get. That at this point, their response is, we are not involved. And so what this does is it includes those duties under Title IX of the director.
Representative Bear.
Thank you, Madam Chairman and Minority Floor Leader. This does seem to be a very important opportunity for us here, but I have a question on page 2 in the definition of what we're doing here on lines 15 and 16 here. It says the director shall widely disseminate. And if you could just share with me, is this a term that's commonly found in statute, or does this need to be better defined? Should we put more direction for the director or not?
Minority Floor Leader.
Thank you, Madam Vice Chair and Representative Bear. When I spoke with the director about this bill a few weeks ago, she thought that this would be something that they would be able to do in each of their DWS offices. And so there are offices around the state, and it doesn't exist right now. And so that's what it would mean. And in the same way that they have other, if you want to call them posters or whatever, in each of their offices, they would now have a new one.
Follow up.
Thank you, Madam Chairman. Follow up, just when I think widely disseminate, I think that, to get the information, they've got to go outside of the office. So did you envision anything like that happening, or is this simply when people come into the office, they would see this information?
Thank you, Madam Vice Chair and Representative Bear. It would be available for people who come into the office, as well as, and I think there'll be some testimony, and there's probably 50 to 100 DWS workers who take calls, and that information will be available to each of them as well.
Representative Bear.
Thank you, Madam Co-Chairman. Madam Majority Floor, you indicated, oh yeah, sorry about that. You indicated that you thought there would be a likelihood that more people would opt into the workers' comp program as a result of this. Did you have any input or any feedback from any of the stakeholders that would indicate that?
Minority Floor Leader.
Yeah, thank you. Thank you, Madam Vice Chair. Representative Bear, I probably shouldn't have said that. That's just my own view, that workers' comp tends to work pretty well and that it's a good system, but I don't know that at all.
Representative Burkhart.
Thank you, Madam Vice Chair. Madam Minority Floor Leader Connolly. So looking at this, and maybe I'm being a little simplistic here, would the way to look at this be it's the workers' comp equivalent of the Occupational Safety and Health Division's consultation branch, where you can ask questions of the safety inspectors without, say, prejudicing them to come out and inspect your facility to get advice and help and that. I mean, they will come out and help you if asked, but is it similar to that?
Yeah, Madam Vice Chair, Representative Burkhart, it doesn't go that far, honestly. We envisioned that as a possibility, but again, because that because we're talking about getting information out to employees and employers of self-insured companies, it doesn't fall under workers' comp, where that kind of guidance actually happens under workers' comp. In order to have established that, honestly, it would have taken an entire new chapter, and it would have taken money, honestly, to administer that. And that's an ombudsman program that you see in some other states. This doesn't go that far at all.
Okay, follow up.
Please.
So Minority Floor Leader Conley, is that something we should think about for the future?
Madam Vice Chair, Representative Burkhart, I think from the data, the information that we get about the use of this, that could be something that we look at in the future. And actually, when I was just speaking off the cuff, and actually goes to Representative Ayer's question before, that I think it's possible that that kind of information, the use of this system, could imply, could give us information that we should set up a different system for as well. And that would include something like an ombudsman program or, obligations for workers' comp.
Follow up? You're good? Anyone else? Committee? No? Okay, thank you. I see we have other legislators in the office. Any other legislator wish to testify? No? Yeah. Okay, the agency, any agencies, please. Please introduce yourself.
Madam Chairman, Jason Wolf with the Department of Workforce Services. I had just made a couple notes here on the bill, and I think just in answer to some of the questions, we do widely disseminate some of the information, as it relates to employers and employees. To be honest with you, I think we could do a better job on information for employers. Employers get hammered with a lot of information, obviously, when they're starting a business. They get it from work comp, UI, Secretary of State. So, I think the part of this bill, I think that really focuses on getting that information out to the employers will help. I think just from anecdotal standpoint, I think as far as the coverage goes, it's roughly about 80-20, somewhere in there. 80% of the employers in the state are required to have workers' comp coverage. The other 20% are what we call optional employers, meaning they can opt in to have our coverage, or they can go self-insure. So with that, I'd stand for any questions, Madam Chair.
Okay, thank you. Any questions? Representative Western?
Thank you, Madam Chairwoman. That 20% stat you just said, can you break that down a little bit so that broadly it's everybody who are not opted in and who are not legally obligated to? Of that 20%, what percentage are folks who, again, are not legally obliged to, but do it anyway?
Mr. Wolf?
Madam Chairman, Representative Western, I don't have that number right offhand. I can tell you again, just kind of from anecdotally dealing with the system for a number of years, a fair amount of optional employers do opt in for our coverage, but there's a fair amount of NAICS codes that don't too. So.
Follow up? You're good? Anyone else? Representative Bear?
Thank you, Madam Chairman. Mr. Wilk, I know that I receive, at least my accountant asked me once a year whether I would like to opt in to have myself covered as a self-employed person. So I guess I've never seen any kind of information that came with that to where what the advantages would be. As an employer, I'm looking at, how can I keep my premiums down? And so I just go with my self-insurance. After hearing the good chairman talk about the advantage of this, I'm kind of wondering if maybe I've made the right decision all along. So I'm curious, when I'm making that decision once a year, is there a way that you believe that you could disseminate that information to the employers that have that opportunity to opt out or opt in?
Mr.
Madam
Wolf?
Chairman, Representative, very excellent question. And I think, we could do a better job. So I procedurally, what happens when we get every business doing business in the state has to register with work comp and unemployment. And from that registration, we determine under workers' comp whether they're optional or required. If they're optional, we send them a letter with a quote of this is how much the policy would cost you to insure these people under our system. I think where we could probably do a better job is give them that information. For instance, if you insure through us, you get what is called the exclusive remedy, which Representative Conley alluded to, kind of the grand bargain. That exclusive remedy under the statute prevents the employee from having a lawsuit against the employer. And that's the main advantage of having workers' comp coverage through our fund that you would not get with if you self-insured.
Thank you, Madam Chairman. Thank you for that information. That's helpful. Back to the once a year choice. Is there any information that's sent out with that form that's turned in each year?
Mr. Wolf?
Madam Chairman, Representative Baird, not to my knowledge, but I'd have to look into that to see. That I think would probably be one of these areas for improvement.
Anyone else? Representative Gray?
Thank you, Mr. Chairman. I am here. And I got to get used to the early starts on this committee, the 7:57 starts. Anyway, I wanted to ask about how this bill is going to change your practice in practice. So, I mean, is it going to change anything in practice when this bill passes?
Mr. Wolf?
Madam Chairman, Representative Gray, yes, I think it will. I think, for instance, to Representative Bair's point, we would, on our optional letter that we send out, we may give a bit more information as to the advantages of our system versus the self-insure. And also, if it's doable, maybe a cost comparison of that.
Follow-up? Anyone else? Okay, thank you very much. Any other agencies wishing to testify? No? Okay. Public comment. Please remember to introduce yourself and
Good morning, Madam Chair and members of the committee. My name is Tammy Johnson. I'm the Executive Director for Wyoming State AFL-CIO. I wanted to just give you an illustration of this in action a little bit. When you go to the grocery store and you go through the checkout line, or you see the people stocking the shelves and the produce, those are the people that we're talking about in the state of Wyoming under this bill. Most of the grocery stores in the state are with private insurance. And those employees have one recourse when they get injured on the job, and that is to let their employer know, and they file a claim with their private insurance. And then those are unilaterally denied. And then the employee gets to figure out how to go about getting their claim met. And they unfortunately, excuse me, I have a little cruddy throat this morning. They unfortunately don't have the resources to pursue a case. So they often just live with their injury. Most of these employees are also not insured on health insurance. They're probably part-time workers and don't have health insurance. So you can imagine it just is a self-fulfilling kind of prophecy. This bill would give them the resources they need, the information they need to be able to take care of their claims and to know what to do, where to go. Imagine if you didn't have the knowledge that you have of the process that you work in every day, and something happens in your life that changes it dramatically. This bill will give those people those resources. There's a lot of employees that you meet every day that are not in the worker comp system. And I think this is so important and helpful to them. So I'm happy to answer any questions you might have.
thank you. Anyone? Representative Burkhart?
Thank you, Madam Chairwoman. So, Ms. Johnson, would the AFL-CIO be willing to help disseminate some of this information we've talked about?
Madam Chairman, Representative Burkhart, absolutely. We do a lot of reach out to our members, and we actually have gosh, I think over 450 grocery store workers who are members here now. And when we spread that information, it goes, to a lot of different people. Mostly we would use our website, but we do mailings to our members as well. So yeah, when we get it, we do forward it on.
Anyone else? Questions? Representative Air?
Thank you, Madam Co-Chair. Ms. Johnson, do you have any idea what the cost to an employer is under private insurance as compared to workers' comp?
Madam Chair, Representative Air, I'm sorry, I don't. I would love to see those numbers as well. I think it would be very interesting. One interesting aspect that you may not know is that teachers aren't covered under workers' comp. There's a very narrow group, people who are like work in the wood shop, people, welding teachers and special ed aides, maybe cook culinary teachers, people who, work with things that might hurt them at work, but teachers don't have much recourse. Their districts typically carry a rider to cover them if they're injured on the job. But these are people that you see every day and that work around you, and you're like, wow, they're not covered. And to help them know what to do is just going to be amazing. So yeah, I wish I did know that, because it's, I think the districts would know what they carry for a rider, what they pay for that, but I don't know what a lot of the private health insurance companies are in Colorado, that I know the grocery stores we work with go through. And so they're even out of state companies. So that makes it even more complicated for workers.
Anyone else? Okay, thank you.
Yeah, you bet. Thanks.
Anyone else wish to testify? Come on up.
Good morning, Madam Chairman, members of the committee. My name is Cindy Delancey, and I'm with the Wyoming Business Alliance. We have our legislative committee meeting on Monday, so we are at this point monitoring this bill. But I wanted to respond to Representative Burkhardt's question about dissemination. Information is always a good thing for the business community, and that I really applaud the effort of the minority floor leader bringing this forward, because this is a real issue for folks, learning what programs are out there, what resources are available. So in addition to Ms. Johnson offering up the ability, should this bill move forward, the Business Alliance also offers up the ability of sharing information with no charge, obviously, but through our newsletter and our outlets to make sure that we disseminate information to the business community. We do multiple newsletters. We do daily updates to over 4,000 people in the business community. So sign us up should this move forward. So thank you very much for the opportunity.
Thank you. Any questions? Seeing none. Thank you. Anyone else wish to testify? All right. Closing public test. Nope. Closing public testimony. All right. Committee, what's your pleasure?
Move the bill.
Moved by Burkhart, seconded by Representative Heiner. All right, committee. Yes, ma'am.
Thank you, Madam Chair. As the committee goes forward, I did disseminate
Yeah.
a possible standing committee amendment. Thank you.
Thank you. All right, committee, should we work it page by page? Page 1. Page 2. Page 3.
Madam Chair,
Yes, Representative Sherwood.
on page 3, I'd like to propose an amendment on line 17 to 23 to delete those.
Okay,
Falling over on page 4, lines 1 through 3 also include in the deletion. And then replacing that section with the phrasing, not later than October 1st of each year, the department shall include information regarding optional employers and their classification on the report required under 2714-201C.
okay.
Thank you.
Do we have a second? Representative Ayer, second. Did you get that, Barb? Okay. Any discussion? Okay, Representative Gray.
Thank you, Madam Chairman. I don't have the amendment, so
right
I'm
here.
finding it, but in practice, what does include information mean? Does that mean there's going to be a report to the legislature? Or I'm not sure what that means, include information. Is this still a reporting to the legislature, or is it just kind of saying that? I don't know. To me, it doesn't make clear where who they're submitting this to. Thank you.
Representative Sherwood.
May I recognize, call a friend?
This is your last lifeline, but sure.
Yes.
Thank you, Madam Chair, members of the committee, for your indulgence. The department pointed out that the language that's there right now would make it very difficult to respond with the specificity that's there right now. They already have a report under 2714 as a 201C that is under workers' comp that is due on October 1st, where they could include that information on that existing report. It saves paperwork, but it makes them pay attention to this section right now, where now they're going to need to report on those who opt in and opt out each year. So there's already an existing report. This is just additional information on an existing report. It reduces paperwork, but it gives us information.
Thank you. Representative Bear.
Thank you, Madam Chairman. So the information that Representative Western was requesting earlier that the director wasn't able to provide would be in that report. What percentages of people are taking up this opportunity and what are not? Is that accurate?
Madam Vice Chair, Representative Bear, yes, in terms of that particular year. And by people, we mean, at this point, we mean employers as opposed to employees.
Anyone else? Representative Burkhardt.
Thank you, Madam Chairwoman. So Minority Floor Leader Conley, the agency has requested this. Am I correct?
Madam Vice Chair, Representative Burkhardt, yes.
Thank you.
Okay. Any more debate on this or discussion on this amendment? Question being called. All those in favor say aye.
Aye.
Opposed, no. Okay, motion has carried. Back on the bill. Page 3, page 4, page 5. Okay. Sensing.
Question.
Thank you. Question being called. Barb, please call the roll.
Representative Bear,
Aye.
Representative Burkhardt,
Aye.
Vice Chairwoman Duncan,
Aye.
Representative Air,
Aye.
Representative Gray,
Aye.
Representative Heiner,
Aye.
Representative Sherwood,
Aye.
Representative Western, and Chairman Greer gave an absentee of aye as well.
Thank you. So Representative Conley, you'll floor manage this. Thank you. All right, moving on, we have House Bill 131. Nuclear power generation and storage amendments.
Madam Chairwoman, do you want me to go down to the table or stay here?
You know, let's be a little more formal.
Yes, ma'am.
It's an important bill, I think. I'm giving you practice for the Senate.
Okay. Thank you, Madam Chairwoman.
Please begin.
Thank you. Members of the committee, I bring to you House Bill 131, Nuclear Power Generation Storage Amendments. And I'll give you a 30,000-foot view, but I will go into details if anybody wants very specific details. What this bill does is addresses two sections of our statute, Section 3511, Article 15, and Article 21. 15 was originally written as a way to address commercial spent fuel rod storage. It was written back, I believe, in the 90s when Wyoming was looking at the potential for a storage facility in Wyoming. Subsequent to that, and I can't remember the exact year, one portion of that statute was amended to include mention of nuclear reactors. And I wasn't here at the time. I can't tell you exactly. Well, I think maybe I was, but I can't tell you exactly the reason for that. But it is included in one section of Article 15, and this bill addresses only that one section. The other portion was in 2019, the legislature passed House Bill 74, which addressed small modular reactors. And it was a very specific bill to those small reactors. And that was, at the time, was a lot of the technology being developed and is still being developed. And the bill was very specific to those reactors and how they operated and where they would be sited and those sorts of things. Currently, there are many more options on the market for nuclear power. And all of these small modular reactors, the micro reactors and other, have come in under a heading of advanced nuclear reactors under the Advanced Reactor Development Program in the Department of Energy. So this bill addresses those issues with advanced reactors and conforms Article 15 and Article 21 so that they do agree with each other and take some other steps towards encouraging the development of nuclear power in Wyoming. It's not meant to address any one particular reactor or project, but all of them in general to set Wyoming up for the future, especially with the jobs they will bring, the economy they will bring, and the numerous other benefits that will ultimately come to the state of Wyoming. Looking at a number of things we are currently doing, especially with our more traditional industries. We're looking at converting natural gas and coal to hydrogen and ammonia to ship. There are already projects on the books to do that. Nuclear power plant is a perfect heat source for that activity. So with all of that said, I will walk you through the bill. And again, I would take a fairly high level approach and target in on those things that the committee members may want more information on. So Article 1506E address the siting of nuclear reactors under the storage capabilities. When you read it, there were some issues with it. Frankly, it wasn't well worded to start with. There are conflicts in there and also with Article 21 between the state of Wyoming and the U.S. Nuclear Regulatory Commission. The U.S. Nuclear Regulatory Commission's position is that they have ultimate authority over all nuclear power plants. Period. Done. States don't. That's a position they've held for many, many years. So Article 15 and changing and amending Article 15 removed those issues and modified them that gives the NRC heartburn, so to speak, over what Wyoming is doing. And it also addresses the storage of spent nuclear fuel at a power plant, which again must comply with NRC rules. And that's the only tie this has with the rest of Article 15. The rest of Article 15 stays in place. There's no amendments to it. It stays as is. This was a very targeted bill to address merely nuclear reactors and the preemption issues and the other things. So parts of 1506E were repealed, parts were modified to make it read a lot better. It requires a number of things that go to our Department of Environmental Quality prior to building or operating a nuclear power plant. And I think clarifies a lot of that language. And that goes over to then to page 4, where we address the issue of Article 21. This was the article that addressed the small modular reactors, SMRs, as people call them. SMRs are merely a type of advanced reactor. And so it broadens the scope of 21 to include those small modular reactors, micro reactors, advanced reactors, and all those fall under the same category. One issue there was in definitions of advanced reactors. Even the advanced reactor development program definitions of advanced reactors are a little loose, so to speak. But if the NRC issues a license for an advanced reactor, that's what this is based on. Mostly they would be reactors put in service after January 1st, 2021. And advanced reactors generally are proliferation resistant. You can't build nuclear weapons out of them. Use an advanced fuel known as HALEU. Use a different cooling system than the light water reactors, although some small modular reactors may use a water cooling system. None of those are currently proposed for Wyoming. Advanced reactors tend to be self-limiting in the current design and technology. So again, it conforms to our statutes to really, in just 2 years, advances in the industry and advances in reactor designs. It amends a number of provisions under 21 to include advanced reactors, deletes duplicate language, and again conforms our requirements to those of the Nuclear Regulatory Commission. Again, lists a number of things that must occur between a company wanting to put an advanced reactor in and our Department of Environmental Quality. For example, they have to indicate a lot of the information that is generally in industrial siting. One thing it does is it does give Nuclear Regulatory Commission freedom to go do what they need with our DEQ tying into that. The review that the NRC would do is, to me, much more robust and in-depth than what would be done for an industrial siting permit in Wyoming. If anybody's interested, I think it's 10 pages and just a laundry list in order of the things you must accomplish with the NRC to get a license. And I don't think the committee wants me to go through that here, but I would be glad to if anybody does.
No, thanks.
Madam Chairwoman?
No, thanks.
Okay, so moving on then, this all necessitated a number of changes and things we've done in other bills. For example, Senate File 59 required power plants, if they're going to convert from coal or natural gas to something else, to be sold if they close them for that reason. What this says is if they put an advanced nuclear reactor in, they don't have to be offered for sale first. And a clarification, these are for advanced reactors. If someone decided to build a conventional light water reactor, all of the other requirements would still apply. So it's kind of targeted towards modern technology and the advanced technology. And that's on page 7, that's 37-133. Moving over to page 8, 37-134, again conforms to what we've done and indicates that retirement does not include converting to an advanced nuclear reactor. Page 9, 37-117, again conforms that requirement for cost recovery, limitations on that cost. 39-23-105 was a tax exemption for demonstration or test reactors. And that was changed to include advanced nuclear reactors that are operated in accordance with 3511-2101. Section 2 are all the repealers. Section 3 requires Department of Environmental Quality and Environmental Quality Council to promulgate all rules necessary to implement the provisions. And Section 4 is a effective date. And with that, Madam Chairman, I'll stand for questions.
Great, thank you. Any questions, committee? Representative Bear.
Thank you, Madam Chairman. Chairman Burkhart. It's my understanding that this particular bill is really dealing with future nuclear plants. It really it's not necessary for us to put the plant in Kemmerer. Is that an accurate statement?
Mr. Representative Burkhart.
Madam Chairman, just so I'm clear, Representative Bear, you mean this bill is not necessary to build the plant in Kemmer? Is that the question? I just want to be clear.
Yes, the experimental plant that is being proposed and moving forward in Kemmerer.
Madam Chairman, I would say, while it appears on the surface, it might not be, I would say it is. We do have to coordinate with the Nuclear Regulatory Commission. Right now, if this is not put in place, all of the work done to put that in, the reviews, the analysis, all that would theoretically have to be done twice. And I don't see a reason to do them twice. Let the NRC do their thing and then have our DEQ come in and do the exact same thing. And that's one of the things that the NRC has issues with Wyoming statutes, is that requirement that the NRC or the DEQ provide permits. NRC just objects to the whole thing. I have an interpretation letter from them that they feel it's an attempt by the state of Wyoming to preempt their requirements and their authority. So I would say, yes, we do need it.
Follow up, Representative Bear?
Just to be specific, without this bill, if it doesn't pass, it would not preclude the installation of that experimental plant. Would that be accurate?
Representative Burkhart?
Madam Chairman, Representative Bear, I think you're accurate, except you would add considerable time and expense to it. You could do it, but in effect, you would add delays to the project. You would add a lot of expense to the project. But I think in the end, you could. This is to alleviate a lot of that duplication of effort by agencies.
Follow up, Representative Bear?
Yes, on page 7, this 27-2, I'm sorry, 37-2-133. And I hope you're more familiar than I am, but the statutes that were created earlier to protect coal-fired power plants from being retired early, I do believe that they exempt experimental plants. Is that an accurate statement?
Representative Burkhart?
Madam Chairwoman, not in that section. That section addresses an exemption for the purchase of coal-fired generation facilities that would otherwise have been retired. I don't think that section, and looking at it quickly, I have it here in front of me, to me does not indicate that there would be an exemption for a nuclear power plant.
You good? Okay, anyone else? Representative Heiner?
Thank you, Madam Chairwoman. Representative, let's talk about taxes just for a second here. For nuclear waste that's going to be stored on site, are there any taxes that will be available for the state because of that nuclear storage? I know there's been conversation in the past about taxing nuclear storage waste. Is that in place or is it not?
Representative Burkhart?
Madam Chairwoman, to my knowledge in statute, there is nothing in place to specifically tax the storage of nuclear waste. Wyoming does not have a waste storage facility. There is waste generated in Wyoming. It's transported out of state. It's not taxed. The taxes on this, the storage of spent fuel rods would be on site, and that would be included in the property taxes, ad valorem taxes, and everything else the plant would pay ultimately. So there would be a value to that storage. So there's not a specific tax on the storage of nuclear materials, but we don't store any anyway. Even the hospital radioactive waste is transported out of state for disposal. So, and there's no tax on it. It's just a cost of doing business.
Follow up?
Thank you. Thank you, Madam Chairwoman. And also this bill repeals the nuclear generation tax of $5 per megawatt. Is that correct?
Representative Burkhart?
Madam Chairwoman, that's correct as far as it applies to advanced reactors. If for some reason someone would call it a conventional light water reactor, or pressurized water reactor in the state, all those taxes would still apply.
Anyone else? Okay. Oh, one more.
Just
Go
one,
ahead.
just one, Madam Chairman. So industrial siding, does the advanced reactor that's being contemplated, the one that I'm most familiar with, has the nuclear portion separate from the steam turbines and some of the electric power generation. So would the Industrial Siting Act be completely done outside of this purview, or would the Industrial Siting Act thereby be able to be utilized for the ancillary part, being the steam turbines and those things most common to coal power plants?
Representative Burkhart.
Madam Chairwoman, for the purposes of this bill, the entire plant, its ancillary facilities, et cetera, would be considered one unit by the state of Wyoming. The company may apply for a license which includes only the reactor portions and some portions of the, as the company has called it, generation island. And that the reason for that is that anything included in the application to the Nuclear Regulatory Commission has to be built to nuclear standards. Even the concrete is different, and it's much more expensive than standard concrete, for example. So if they build, if part of it was I'm just picking something here, a 10-car garage for their vehicles, they would have to build that to nuclear specification. So the idea was to leave that out, but for our purposes here, we've included it so that you don't get, again, a dual review. Also, it would be possible to take, call it the generation facilities, divide them up to a point where none of them would meet industrial siting. So this puts a very strong review through the NRC on all of that, and I think it's a very appropriate way to go.
Follow up.
Thank you, Madam Chairwoman. So thereby, will there be any money available for the communities for mitigating impact that is normally through the ISC, handling through that procedure? Is there any way to take care of mitigation without the Industrial Siting Act?
Representative Burkhart.
Madam Chairwoman, I think so, because in industrial siting, you have mitigated and unmitigated impacts. The mitigated impacts still stay in place. The unmitigated may not be as heavy to the company as they may have been if you look at doing industrial siting on the whole plant. And that the mitigating impacts, I would let the companies involved in that speak to those themselves, because they will have to make changes in the community for infrastructure in any number of things.
I have one follow-up to your question, and then maybe it'll answer yours. So Representative Burkhart, so if the plant, as such as it is, if they expand beyond its footprint and goes much further beyond the footprint, would then it qualify for the unmitigated or further mitigated as such as I think the direction that Representative Heiner is going in terms of industrial siting? Would that qualify versus, because I think the difference is, correct me if I'm wrong, an existing plant versus a new siting location of a project. So if a current project, like what we're talking about, goes beyond its footprint, would that justify or kick it into a industrial siting?
Madam Chairwoman, if I may ask a question for clarification, when you say footprint, you're talking about the footprint of the existing power plant.
Correct.
Thank you, Madam Chairman. So any of these plants, whether it's the one contemplated in the western part of the state or any one being built at another power plant, will extend beyond the footprint of the existing plant. You just cannot keep them, say, inside the fence. They're generally too large. You need support for them and that. And I can't remember the exact area the current one being considered would cover, but they will extend, call it beyond the fence of the power plant. And that I know that at the one in the western part of the state, the interference is at the coal mine. They because of the NRC's requirements on geology, They can't build that on top of the coal mine or on top of reclaimed areas. It has to be very geologically stable. One of the things that's looked at for a power plant that frankly, I don't think industrial siting really looks at very hard. So it would extend that, but industrial siting is based mostly on money, not in actual area.
Oh,
And so industrial siting of the project, and I would let the agency speak to this. I believe the number is in the upper 200 million range. I have a number in my head and I'm going to round it off to say about 280 million more currently involves industrial siting. So if you keep that number under there, you don't impact industrial siting. And I can see a variety of ways to split up a power plant to avoid any industrial siting, even currently. So, but the footprint will extend beyond the plant. It would on any of them, mainly due to the size. I think they'll take up about 100 to 200 acres, which is significantly less than call them a traditional power plant. I think a number of people have seen pictures of the Vodal plant in Georgia, and that covers sections of land. These won't. Compact, very unobtrusive from an optic standpoint. And I hope that answers that question.
it does mine. Okay, last chance. Go ahead.
Thank you, Madam Chairwoman. Appreciate the opportunity to ask another question. This bill as proposed, Representative, it exempts them from Senate File 159 to offer for sale a retiring coal plant. Could it be possible for the utility to put a small modular nuclear plant by the side of a huge coal-fired power plant such as Jim Bridger, and thus exempt that entire large coal-fired power plant from being offered for sale because of a small micro nuclear set by the side?
Representative Burkhart.
Thank you, Madam Chairwoman. Under the current statutes that, yes, you could do that. I don't think that's reasonable, but under the current statutes, you could. Under this statute, you could. But when you look at the statutes in 159, part of the issue there was the way they were worded when it said offer for sale a plant that is being retired that uses coal or natural gas. An alternative would be to fire one of those plants with ammonia. Most people don't realize ammonia does burn. We all picture it as the stuff you buy in a bottle at the store to clean your house with, but ammonia is really a gaseous material that in its own will burn, or to convert them to hydrogen. The way the current statutes are written, you'd almost have to read them that if you converted the power plant to run on hydrogen, you would have to first offer them for sale. And I don't think that's correct, that we should require a company to offer an asset for sale just because they changed the fueling material or how they generate the power. So that's one part of it. And who knows, there may be some other things in the future that we don't even know about or can contemplate right now that again would say, we want to convert to this. We want to convert to nuclear fusion. There's some reports that may be closer than any of us think. Then again, they would have to sell it first in order to convert their own property. And I think if I remember correctly, I may have disagreed with that portion of that statute even when it was written, to require them to sell it just because they retired from using coal or natural gas. At first, it was only coal, and then natural gas was added in later into 59. So, but yeah, you could answer your question. You could do that.
Representative Sherwood.
Thank you, Madam Chair. On page 9, under the exemptions, does that include a sunset? Thank you.
Representative Burkhart.
Madam Chairman, no, it does not. There is no sunset. There's none in the existing statutes. And for example, if someone say decided they wanted to build a light water reactor here in Cheyenne, all those taxes would apply. It only applies to those reactors being built with advanced technology.
Representative Bear.
Along the same lines, thank you, Madam Chairman. Chairman Burkhart, what was the purpose of this particular language when the legislature wrote this, exempting specifically tests or demonstration? I understand the small modular, that was kind of the technology at the time, but why were we exempting only the test and demonstration one? This obviously, this change that we're looking at here, and I remember testimony from Terra Power and Rocky Mountain Power that this would allow them to build future plants and not have to worry about this additional tax. So what was the original thought of exempting these demonstration plants?
Representative Burkhart.
Madam Chairwoman, Representative Bear, vaguely, I remember, and I hate to say this because I was a co-sponsor of that bill. The concept was to encourage technological development to bring those here. The small modular reactors. There were companies at the time who were making great public pronouncements on the availability of their equipment. And it was to encourage them to bring them here for testing. And I think what we ignored at the time was the fact that after they're tested, they would stay in place and produce electricity that can be sold for, we get sales tax on electricity. We get the property tax on the property. We get severance tax on the uranium that's mined. And that was most of the logic there, was to encourage a technological development rather than looking at it as a potential for a continuing future business enterprise.
Follow up.
Thank you, Madam Chairman. What was the purpose of having this additional tax on nuclear?
Representative Burkhart.
Madam Chairwoman, again, it was the technological development of those. And I can't tell you exactly why it ended up targeting nuclear power over any other power generation. The only other power we really tax in a similar manner would be the $1 per megawatt on wind. And why it was $5, I apologize. I do not remember the answer to that one. I think we could probably go back and listen to the floor debate on that, which I have not done.
Representative Bear.
Thank you, Madam Chairman. Is it possible that it was an effort to protect coal?
Representative Burkhart.
Madam Chairwoman, it could have been, yes. But, and again, it was at the time, the small modular reactors that were being considered were, I got to think of a dimensional thing here, probably about the size of a commercial hot water heater. And to protect some coal. However, I look at the reactors as being very compatible with coal. The heat from the reactor can be used, frankly, at the Naughton plant to convert the coal at the Naughton plant to hydrogen and ammonia. And it's another resource we can continue to use our coal.
Follow up.
Thank you. And sorry, Madam Chairman. Two things you've mentioned that I'm interested in knowing. How far are we away from the technology to allow this ammonia conversion and operating that way? And another question is, well, I'll just let you answer that one first and then I'll follow up.
Representative Burkhart.
Madam Chairwoman, it's here. There are 2 projects already on the books being considered for Wyoming, one in southwest portion of Wyoming to generate ammonia to ship to the West Coast. One of the large auto manufacturers is running about 10,000 vehicles on hydrogen. So it'll be shipped as ammonia. It's easier to ship ammonia than hydrogen. Hydrogen causes embrittlement in mild steel lines, so you have to use stainless, but it's easier to ship ammonia, get to the West Coast, convert it back to hydrogen. So there are 10,000 vehicles. There are some companies looking at putting hydrogen fueling stations already in Wyoming. So that technology is there. The one limiting factor Wyoming has on it is the fact that the so-called green hydrogen, which is electrolysis from wind turbines, we don't want to give up our water for that. Our water is becoming so valuable, it may be one of our most valuable resources in the future. So converting coal to hydrogen and ammonia, converting maybe natural gas, which is relatively easy, that technology exists. And as I said, there are 2 projects on the books. The state has just recently awarded grant money on one of those at least.
Representative Bear.
Thank you, Madam Chairman. This will be my last question. So when I look at the concept of mining uranium and ad valorem tax on a on the uranium that we will use in, power plants throughout the country if we move forward and this is a successful plant and we spread this out throughout the country. Still, it's a minute amount of material that comes out of the ground, and the ad valorem I see as very limited in comparison to coal. Is that an accurate statement in the kind of coal we're sending out of the state now?
Representative Burkhart.
Madam Chairwoman, it is accurate in a way. You sell less uranium volume wise or weight wise than you do coal. And I haven't made the comparisons, but I think yellow cake is going for a couple hundred, 250 or so, which is the form of uranium you sell, $250 or so for the average quantity of yellow cake. Coal, we sell a lot more, but it's going currently for about $12 to $13 a ton. Yellow cake sold by the pound. And that, although coal has spiked recently on the spot market to about $30 a ton, our coal companies are making good money right now, even though the volumes are down. I don't think the uranium will supplant coal. But at one time, Wyoming was the country's largest producer of uranium. We still currently have the largest reserves in North America right here in Wyoming. And that the limiting factor on that too will be enriching the uranium to use for the fuel. And there has been some talk from a number of enrichment companies looking at Wyoming for expansion. So it would be done here. So bringing lots of potential economic benefits to the state.
Done? Okay. I believe you're off the hook for now. Any other representatives in the audience that'd like to testify? Welcome, Representative Henderson.
Madam Chairwoman, may I resume my seat at the front? Thank you.
You've done well.
Thank you, Madam Chairman and committee. Well, this feels like coming home. I just want to say,
Make sure you introduce yourself. for
sorry.
those.
Everyone knows I'm Bill Henderson from Cheyenne. I just want to say that I really want to compliment the previous speaker. His leadership in our state is tremendous. I want to be on record for that, because I'm sure you do. He mentioned hydrogen, and I just want to try to tie together, please, real quick, the concepts that we have in place and the agencies. We have the council, we have economic development, we have local, right? Right here in Cheyenne, the capital city, we have a business that's been going for some time that was able to get started because of the local economic development agency, Cheyenne leads, and setting them up on the Swan Ranch Industrial Park over here. They do this hydrogen, and they have a distribution point in San Diego. So this is working right out of our state, and it's growing. They put millions. They started through our process, and then they put a couple million into of their own, and then they bought it. And then those millions are going back into the process to help continue. That's all I wanted to say, is show my support for this. Thank you.
Any questions, committee? Okay, thank you. Any other legislators wish to testify? No? All right, state agencies, please.
Thank you, Madam Chair. Todd Parfit, Director of the Department of Environmental Quality. With me here is Luke Esch. He is the Administrator of the Industrial Siting Division and also the Deputy Director.
Thank you. Welcome.
So just would like to start out by talking about Article 15. There are two articles in the bill, Article 15 and Article 21. Article 15 was explained, I think, very well by Representative Burkhart. What 1506E, the provision that's being considered for amendment, provided, what it did is it provided an automatic legislative approval if waste was produced by a nuclear power generating facility within the state of Wyoming. With a caveat, you still have to comply with 1502 through 1504. And what that is the application process, which includes a $900,000 application fee. And then there's a report that the agency would have to prepare in examining alternatives. And that process takes better part of 3 years. And then there's the public participation component of the process, which is 1504. What I do want to address is the 1504 also talks about the need to have, what is it, you can't submit or you can't complete the process of 1504 until there's a permanent repository and a final EIS has been issued by the Department of Energy and an application for a license submitted. What this amendment would do to 1506E, that would allow this process to move forward. So right now, I think Representative Bear asked a question on whether or not Article 15 would prevent the proposed facility at the Naughton plant. And the answer is, well, not exactly, but until that permanent facility had a final EIS, the answer is yes, it would prevent that. And we've determined that the proposed facility would be subject to Article 15. So these amendments would remedy that and allow for the siting of a nuclear power plant within the state. There really is only one alternative, and that is the Nuclear Regulatory Commission would require that any spent nuclear fuel would be stored at the site. And so there's not much of an alternatives analysis that we would be completing anyway. But as was mentioned, the NRC has a non-delegable authority on the oversight of the siting of the nuclear power plant. We cannot become an agreement state for that. We are an agreement state for the mining and milling of uranium and thorium. We cannot become an agreement state for the siting of a nuclear power plant or the storage of the spent nuclear fuel. That would be licensed by the NRC. So we think the change is appropriate. You would still need an NRC license to construct and operate a facility. And we would participate in that process with the NRC through the NEPA process and through the licensing process. There's an addition to 1506E, which is the reporting requirements. Those reporting requirements would be around the jobs created, local and state sales tax generated, and other benefits and impacts. And then there's also reporting on copies of publicly available reports, notifications, and violations that would occur. So anything that would be sent to or from the NRC would also be sent to the agency. And it's also important because there's been some discussion about industrial siting. It's explicit in Article 15, 1502 that under Article 15, it exempts facilities from jurisdiction under the Industrial Siting Act. Now, this is just for Article 15. That's not the case for Article 21. So in short, it addresses concerns raised by the NRC over preemption. Representative Burkhardt talked about some correspondence that we had received from the NRC. We've had follow-up conversations with the NRC, and I think this remedies their concerns. So that's the Article 15 component. On Article 21, the amendment defines advanced nuclear reactor. And that's a little clearer definition, I think, than the modular definition that exists currently. Page 5, line 17 suggests that the Industrial Siting Act applies to a certain extent. One thing I think was brought up in the discussion, would impact assistance still apply? Well, the way I read it is that it would, because industrial siting would apply to the extent it doesn't duplicate or conflict with the NRC's action. NRC does not have an impact assistance process. So I would say that it would still be eligible for impact assistance. And there may be other components of the Industrial Siting Act that would be relevant. The jurisdictional amount is 231 million. So anything over 231 million would be jurisdictional. And then we would have to parse out what is being covered by the NRC and what is not. And we would cover under the way this is structured right now, we would be able to cover everything that is not covered by the NRC licensing process under industrial siting. Now, I will say on page 6, line 4, Romanet 2, that does create a little bit of confusion and not entirely clear of what that means. So that's something that we would just suggest that you take a look at.
Representative Heiner.
Thank you, Madam Chairwoman. So, Director, I see where you're coming from. Would it be better if we deleted lines 4 through 6 on page 6, such that we could let the NRC do all the things they need to of the nuclear portion, but on the steam turbines, and which is very separate from the nuclear, that's actually located in a different area, that would fall under the purview of the Industrial Siting Commission. If we deleted those 3 sentences right there, would that make cleanup?
Director.
Madam Chair, that would certainly make it clearer to me as to what the meaning is, because we're already identifying and acknowledging that we're not going to incorporate anything or regulate anything that is covered by the Nuclear Regulatory Commission already.
Good. Okay, please continue.
Okay, and then the last thing that Article 21 does is it incorporates the same reporting requirements that are in Article 15, provided that they're not already submitted under Article 15, which we think is appropriate. And overall, I think it just, the changes that are proposed here simplify the Article 21 process overall. So that's, we'll just stand for any questions.
Any questions? Representative Bear.
Thank you, Madam Chairman. Director Parfit, the items that you mentioned, the $900,000 application fee, the 3-year timeframe that it would take to go through that process for the disposal. Is there any exemption in 1506 for demonstration plants?
Director.
So Madam Chair, not that I'm aware of.
Anyone else? Okay. Representative Gray.
Thank you, Mr. Chairman, Madam Chairman. Mr. Parfit, Director Parfit, so I understand this, your interpretation, if this bill doesn't pass, NRC, let's say NRC permits the facility, but we don't have this process, the facility cannot proceed, correct?
Director.
Madam Chair, my understanding is 1504 requires that before we can complete the process, that there would have to be a final EIS and a license application submitted for a permanent repository. And so until that exists, we wouldn't be able to complete our process as it stands currently under Article 15.
You good? Okay, thank you. Representative Burkhart.
Madam Chairwoman, if I might make just one quick comment, not a question.
Proceed.
Thank you. The repository, just so everyone's clear, and it's terminology a lot of us have used, is what everyone calls Yucca Mountain. It was never approved. It probably will never be approved. So thank you. I just wanted to clarify that.
Okay. All right, thank you. Any other agencies wish to testify? All right, public testimony, public comment.
Madam Chairman, members of the committee, I'm Travis Detai with the Wyoming Mining Association. In support of the bill, we appreciate the bringer of the bill. This has been a great discussion, and I think what it can be taken from this today, and I won't be long, Madam Chairman, we're on the front edge of something that could be really big for Wyoming. And it's good to get these, to smooth the road up front right away. That's what we're doing here today. We believe the bill does that. You probably have to come back and revisit some things at some point, but we're starting to smooth the way. The implications for the uranium industry in Wyoming with the TerraPower project and future projects is huge. And we have a great opportunity in the state of Wyoming to go from to be a one-stop shop from point A to the start to the finish in the nuclear fuel cycle and industry. And this work has to be done up front. Time is of the essence. They've got a 7-year window. Everything needs to be smooth and to make it work. And this is going in the right direction. So, Madam Chairman, members of the committee, we support the bill.
Thank you. Any questions for Mr. Detai? Representative Burkhart.
Thank you, Madam Chairwoman. Mr. Detai, if there was considerable advance in the number of reactors, economically, what would that mean to uranium mining in Wyoming?
Madam Chairman, Representative Burkhart, our guys, our operators are right now on standby. The opportunity to provide the fuel, domestic fuel, I don't think you can understate what it would mean for Wyoming. Back in the olden days when we were really producing heavy, we were producing anywhere from, 7 to 8 million pounds, 10 million pounds. Right now it's negligible. We have the capacity to do that and more. So I think, this is the starting point, and this is the opportunity is immense, I think. I'm not sure that answered your question, Representative, but the opportunity there for expansion and to get our industry back on our feet. And we're not talking next year, but 5, 6, 7, 10 years down the road. And the opportunity, as where the coal industry is right now and the trajectory that we're on, we've got an opportunity to bolster up another industry, to take that spot. Probably not financially as much as coal has done for us in the last 15 years, but we have something to look forward to make up some of that.
Okay. Representative Bear.
Thank you, Madam Chairman. Mr. Detai, you heard me ask the question earlier about that very subject, about the replacement of coal. If you could just elaborate as far as percentages, how does this compare? And I know that it's difficult to say because we don't know how many nuclear power plants will be built. You did make the comment, though, that our uranium production could be ramping up in 5, 7, 10 years, but this plant isn't due to open up for 7 years. So is that need to be adjusted or?
Mr. Detai.
Madam Chairman, to the first part of your question, I think Representative Burkhart hit on the volume issue for coal and uranium. The financial and revenue return from uranium is probably never going to be what we've reaped from coal in the last 15 years. So it's not a full replacement. And the answer to your second part of the question is, not just what's happening in Wyoming, but what's happening, globally. I think with the direction and the new interest in nuclear to meet our, whatever you think about the climate issue, nuclear is getting much more attention. And, it's going to depend on the price of uranium right now. And I think that price is hovering around $25, $26 right now today. Once that price gets up and, around $40, $45, you're going to see Wyoming producers start ramping it up again. And I think that's reasonable to expect in the next 2 to 3 years. So it will happen. We will start producing and start ramping up before the Natrium project is finished.
Anyone else? All right. Thank you.
Thank you, Madam Chairman, members of the committee.
I saw Senator Anderson. Did he sneak back out again? Oh, there he is. You don't want to testify? Okay. Anyone else? Please remember to state your name.
Hello, Madam Chair and rest of the committee. My name is Stephanie Kessler. I'm with the Wyoming Outdoor Council. Thank you for this time. I emailed you all this morning a handout, but I don't know if you've gotten it, and I have hard copies if you would like that.
We have it.
Great. First of all, I'd just like to concur with a lot of what you heard from Director Parfit this morning regarding his analysis. And I really wanted to emphasize through this handout that we absolutely agree that through the NRC, the state of Wyoming does not have the authority to regulate radiological safety matters. And I'll be the first to say I know the agency doesn't have the staffing or the program either to do that. But it has been litigated and clarified in court cases that states absolutely have the right to fill in on other matters that do not fall under the NRC purview regarding probably mostly socioeconomic impacts regarding a facility. And that's what this fact sheet mostly addresses, is that history, that we have lots of opportunity through our Industrial Siting Act to take a good look at the facility and think about it in terms of the impacts it can have to our community, and raise issues, frankly, in that process that the NRC probably is just not going to come up with. Examples that come to mind for me are transportation routes. Do they understand what our roads are like in the winter? Do they have preparations for that? Is their facility ready for the extreme low temperatures that we can get in our state? And also, you'll see that it addresses a lot of issues that's certainly not under the NRC's purview, which is impacts in terms of local economic needs for housing, transportation, sewer, education, police and fire facilities, et cetera. So we believe the Industrial Siting Act is a great Wyoming law that we should ensure is strongly a part of the process of any new plant that we're talking about, so that Wyoming people, Wyoming rights and concerns are robustly addressed. And it also provides lots of transparency, lots of public information, and lots of opportunity for local engagement. And we want to support local people and governments having all of that access and understanding and engagement in this process. With that being said, I'd like to just go over some, I guess, issues with the bill itself in terms of mostly cleanup, but are some interesting gaps that I just would like to point out to the committee on the bill. Starting on page 3, and we're now in Article 15. I just want to let people know that Article 15 was written as a supplement or under what is our Federal Nuclear Waste Policy Act. It's all about waste storage. It has nothing to do with nuclear reactors. That falls under our nation's Atomic Energy Act. And that's what Article 21 is about. However, on page 3, line 12, with this report that's there, it's about a nuclear electric generation facility. So suddenly we're inserting into Article 15, which is only about waste and everything under the Nuclear Waste Policy Act federally, something about the Atomic Energy Act. So we're kind of mixing up apples and oranges. I don't know why that's there. Maybe it was meant to say just about the waste, but it seems to be wedging in a big report about a reactor, which is not falling under this article. Then flipping to where it does get to Article 21, which is more Wyoming's approach towards the Atomic Energy Act. I just want to point out in the bill on line 20, it has changed the title of the article to Advanced Nuclear Reactors Requirements, but the statute is still small modular nuclear reactors. So I think you will have to amend that language if you want to change it to that it's all about advanced nuclear reactors, because right now it still says small modular. And then on page 4, line 22, it jumps right to B. But I want to indicate that again, in the statute under A, it still talks about small modular nuclear reactors. So there's a lot of conforming amendments that I think you'll want to make if you want this to be a broader category and not just talk about small modular. Moving on, another area that I'd like to point out is on page 5, line 10. You do define under little 3I, the advanced nuclear reactor, but what again is not either eliminated or amended is that in statute under little I, A, it says that it's still restricted to only not more than 300 megawatts. So you haven't eliminated in statute the requirement that none of this can be above 300 megawatts. And I understand that that may be a need. So again, there's a need to conform what's in statute with the rest of what you're doing in the bill. And then particularly on the bottom of line 5 in lines 21 and 22, this has been referenced a lot. I sat through all the meetings regarding the small modular nuclear reactor development of this bill several years ago. And this amendment was actually only put on in a floor debate. So it was really, not broadly discussed, but I think it's very important for the state of Wyoming. And I'm thinking that the word interfere with is very broad, and I don't know how that would be interpreted, to be honest. The NRC could just say to the state of Wyoming, hey, for us to go through the burden of participating in your Industrial Siting Act interferes with our schedule, our desires, or whatever. It's squishy. I don't know what it means. I don't know if it's a legal phrase. I suggest to strongly affirm the state's right to implement the Industrial Siting Act on our terms, that we instead use the NRC's own language, which is about preemption, and instead say that it shall not preempt with NRC authority nor duplicate it, and just leave it as that. I think those are my main comments for now, and I'd be glad to work with the committee on any of the cleanup that I've mentioned, and I'm here for questions. Representative Burkhart.
Thank you, Madam Chairwoman. Ms. Kessler, you made a comment that on page 521, line 21, 22, were floor debate and was not broadly discussed. Are you suggesting that the legislature does not consider these matters an open floor debate and that that's not a broad enough discussion for your purposes?
Ms. Kessler. Madam Chairman and Representative Burkhart, in no way. What I was just saying is that it was never really brought up in committee and it didn't have that more committee work time on it.
Follow up, Madam Chairman.
Follow up?
So, Ms. Kessler, you're suggesting that any matter brought before the legislature cannot be amended by a member to come up on committee of the whole, that everything has to be taken up in a committee?
Ms. Kessler.
Madam Chairman and Representative Burkhart, no, I am not applying that. I was just giving some of the legislative history from my experience.
Anyone else? Okay. Thank you.
Thank you.
Okay, we're
Madam
running up to 9:35. We still have another bill. So
Madam Chairman, there's someone waiting online.
for this bill,
Yes.
okay. Can I see a raise of hands of anyone else that wants to testify on this bill? Okay,
I brought him into the room.
okay, thank you.
Madam Chair, thanks. I'll be very brief. I know you're up against a time deadline. Jeff Navin with
Sorry,
TerraPower. Oh, sorry.
I'm sorry. We have someone else sitting here at the table, so I'll call you in just a moment. Go ahead.
All right, thank you, Madam Chairwoman, members of the committee. Shannon Anderson from Powder River Basin Resource Council. And I have with me Michelle Irwin, who many of you probably haven't had the pleasure to meet. She is our community organizer in Southwest Wyoming. So she works directly with the communities of Kemmer and Rock Springs and our interest in Southwest Wyoming to help those communities think about how to transition their economies moving forward in the new energy future that they face. So just wanted to introduce her to you as well. So on the bill specifically, I'd walk through some additional concerns and items that we've identified in addition to what Ms. Kessler already laid out. Starting with on page 3, line 1, there's the implication that you would get a construction and operation license. That's what's called a combined license in the NRC vernacular. It's my understanding that the TerraPower facility will actually have separate licenses for both construction and operation. So you may want to think amending that sentence to have a plural or specifically reference combined or separate licenses for construction and operation, just to be compliant with what they will actually be doing. Later on that page on line 11 goes into this report that you're having the operator prepare. The first kind of response again is to what is the operator? You may want to think of licensee or another term for who's doing that report. This is a report that's going to be produced prior to operation. So there actually probably won't be an operator at that time. And just again, to think about who is actually responsible, especially in the case of the TerraPower facility. You have a company that is building the facility and another company that's probably operating that facility going forward once it's built. So again, unless the term operator is defined somewhere, I would just encourage you to change it to licensee or something like that. The bigger issue in that section is really the time frame. So this report will only be produced 30 days before construction. First of all, you might want to say commence construction, not construct. Those are two different terms. So you might want to just say commence construction. But regardless, the 30 days just simply doesn't give anyone enough time to act on any of the findings in the report. At that point, really is just a mere formality that's not helpful to any kind of decision-making at the local, state, or federal level. Going to page 4, line 14, we have concerns about the 15-day time frame. And we believe that there should be simultaneous sending for any report generated by the company. That's easy enough for them to do. If they're already sending it to the NRC, send it to the state as well. That's very simple. And if it's coming to them, maybe a 24-hour period would be more applicable. And this is really important for local emergency management in the area. And we would include the report. We would encourage you to amend this provision to send the report to them as well. Because if there's any issues at the facility, again, we want our local folks on the ground to know of those immediately, as soon as possible, and to be able to respond to them. So the 15-day period just isn't enough it's too long of a time period to be able to address any of those issues that may come up from any of those notices or violations that the reporting requirement addresses. On page 5, line 12, this definition, I think there is a real concern about what is improvement and who defines that, who determines it, what the criteria is for that. As you remember, we had a discussion in Casper about the definition that you had in the proposed interim bill. There were some flaws in that definition, but at least it did have criteria. This definition is without that at all. And I think it's going to be very difficult for anyone to know what an improvement is and understand what that means in terms of regulatory compliance. On the bottom of page 5, top of page 6, this is to what Ms. Steph Kessler was speaking to in terms of the Industrial Siting Act review. We really do believe it should be the state should exercise its maximum authority to regulate for public health and safety and to take advantage of all the authority that you have in the state that isn't explicitly preempted by the Nuclear Regulatory Commission. So I would echo what Ms. Kessler said and hope that you do take that up in terms of an amendment that addresses that. And likewise, we believe that Romanet 2, which deals with any adjacent facilities, that you should strike that. And those adjacent facilities should specifically be subject to the Industrial Siting Act review. There's no reason to exempt those adjacent facilities. If you remember, the Industrial Siting Act was actually all about power plants and making sure that we address the socioeconomic impacts of those power plants. And we just believe that it's really important to make sure that power plant and power generation facilities are not exempted from Industrial Siting Act review. In this case, of course, we're talking about a potentially $4 billion facility, well beyond the jurisdictional thresholds of the Industrial Siting Act. If there is any facility in Wyoming that has ever been contemplated that should apply to the Industrial Siting Act, is this one. It's an enormous facility with enormous numbers of construction workers, any kind of implications for local emergency management, as Ms. Kessler was saying, roads and transportation patterns. Those are exactly the kind of things that the Industrial Siting Act was designed to do and to regulate and to make sure that those impacts are mitigated. So again, I just encourage you to exercise the full authority of the state. That isn't specifically preempted. It's your power to do that and to make sure that you are addressing those local impacts. On page 6, line 8, there's the same 30-day issue. Again, it turns the report into a mere formality that has no meaning for any decision makers or local government or anyone else. On page 7, line 7, there's that same issue again of the timing for the reporting requirements. Going to the power plant sale issues and the Public Service Commission part of the bill, page 7, line 20, organizationally, we were opposed to Senate File 159 altogether. So we're okay with this new addition to this provision, but would note that it doesn't include things like storage. At which point I think there's an interesting issue of whether the storage component of this facility is also exempted in the same way that the nuclear component of this proposed facility would be. And it doesn't include things like natural gas conversion, which you might have read the paper this morning. There is plans to convert power plants to natural gas. And I think there would be a question of whether if we're going to bring in advanced nuclear, why don't we also bring in natural gas conversion and other things that a power plant is converting to exempt them from that Senate File 159 process. On page 8, line 11, there's the same comment regarding the existing language there that was put into place through House Bill 166 last year and the definition of retirement. And then on page 9, line 12, regarding the taxation, this is where that definition of advanced reactor really matters. Because you're having the Department of Revenue essentially determine what an improvement is. And to know that because if it's an improvement, over existing nuclear power, then you get that exemption from the tax. So you're actually going to have the Department of Revenue understand what that means and have some criteria related to that to know whether the exemption applies or not. And I don't know if the Department of Revenue is capable of doing that or not. And I would just note again that I think it would be helpful to have some tax related to this facility. There's a lot of good back and forth, I think, about the life cycle revenue that could come from uranium and elsewhere. But as was previously mentioned, the fuel that will be used for this facility is HALEU. It's different. Cannot be produced in Wyoming. And so there won't be those ancillary benefits related to nuclear power generation here. So it's more akin to like a wind project, frankly, where we do have $1 per megawatt hour taxation. And I think it's important to maybe contemplate that going forward for the state to provide adequate revenue going forward. So with that, I'd be happy to answer any questions. And I do apologize, none of this was written up and given to you in advance, but it's been a busy week, so thanks.
Committee, anyone? Okay, thank you.
Yeah.
Next. Hustle. Yes.
Madam Chairman, Bill Winnie, Sublette County, spent a career in the Navy nuclear propulsion program. And at one point served in the office of the Assistant to the Secretary of Defense for Atomic Energy and saw into nuclear bureaucracy up close and personal. One of the things you need to make sure as you go through this process, and there's nothing wrong with the bill as it stands, but make sure in the long term you continue to have a single decision authority for state issues. You're always going to have the Nuclear Regulatory Commission guys. That's part of the process. But making sure the bureaucracy doesn't slow things down, that's important. That was one of the strengths of how Admiral Rickover set up the Navy program. To the extent that siting allows, we should be looking long-term in terms of replacing all of the conventionally fired power plants with some kind of nuclear power plant. A couple or three technical issues you might take note of. We talk about megawatts with regard to nuclear plant. You have megawatts thermal, output of the reactor, and megawatts electrical. And I believe the way you refer here, it is to megawatts electrical, but that is at least half of the megawatts thermal number. With regard to Representative Heiner's question about the secondary side of the plant, keep in mind that there are some older designs of nuclear plants not contemplated in the natrium thing, but they were boiling water reactors. They do contaminate the secondary plant. And in any event, you could have material failures that could contaminate the secondary plant. It's not particularly high level, but it could be there. And then keep in mind, the mining guys talked about uranium. Wyoming's got a lot of potential to develop thorium. Subject to questions. Thank you.
Any questions, committee? Representative Bear.
Thank you, Madam Chairman. I'm sorry, I didn't catch your last name, so. If you could just-
Winnie, W-I-N-N-E-Y.
Thank you, Mr. Winning. You talked about a single authority. When you look at this bill, do you see it as more than one authority from the state government standpoint?
Mr. Winnie.
Madam Chairman, Representative Bear, no, I didn't see that in there, but I also didn't see it addressed either. And so that's why I raised the issue. If it's all consolidated into the environmental guys, that works. But the point being 1 point, and you have potential to be broadly spread. And we've seen other nations in the Navy nuclear programs have real problems with that.
Anyone else? All right. Thank you, Mr. Winnie. All right, and we'll go online.
Great. Thank you, Madam Chair. I will be brief. Jeff Navin with Terra Power. Thanks for the opportunity to testify today, and thanks to everybody who worked on this legislation. As noted, we think that the Natrium project is consistent with the intent of the current law. As Ms. Kessler noted, however, there are a few technical corrections that we will need to see to ensure that we can go forward. This gets to a question that Representative Bear asked earlier in the hearing. Under the current law, the limit of the size of any reactor is 300 megawatts. Ours is 345 megawatts, and it feeds an energy storage system that can store up to 500 megawatts of electricity. So that piece is addressed in this bill, and without that piece being addressed, we're going to have some trouble going forward. And also agree with the comments by DEQ about the need to clarify the waste piece as well. We think this, we support broadly what this legislation is attempting to do, and we think that it'll allow us to keep our project on schedule in Lincoln County. We continue to be grateful for all of the work that the committee's done to learn about our project and the technology, and to ensure that we can move forward in southwestern Wyoming. Happy to take any questions.
Thank you. Committee, any questions? Representative Bear.
Thank you, Madam Chairman. Mr. Navin, you mentioned that you believe that the plant that you're building is consistent with the current law. Obviously, there's a few things that need to be cleaned up, the 340 megawatts versus 300, the power, the storage of the waste. We've seen that there's some problems with this particular bill, needs some more work. Timeframe wise, if we were to get a bill out, when does it need to happen to keep from inhibiting your efforts?
Thank you, Madam Chair, for the question, Representative Bear. I think, we are not planning to seek our construction license until the end of next year. So we do have a little bit of time to clarify these issues. But we also, more clarity early on in the process allows us to continue to move forward with our planning and the like. So certainly willing to continue to work with the committee as you develop this or any subsequent pieces of legislation.
All right. That will close public testimony. And since we are up against 9:52 and we need to hit the floor, go ahead, Representative
Thank you.
Greer.
Thank you, Madam Chairman. Members, what we'll do is we'll take this up at 8 o'clock on Monday morning. Okay, the next scheduled item will be the House bill House Bill 135. Concept will be is we'll work this bill as a committee with public comment is over. We'll work through it. I caught only half of it. We all have lots of commitments at this time. I would suggest committee members, if there are cumulative amendments or amendments that we're thinking about, is this get them worked, this get them written out. To the extent that you can, that's probably the best way to move forward with it. So, okay, that's my comments. Thank you.
We're adjourned.